The flashing blue lights appear in your rearview mirror. Your hands tighten slightly on the steering wheel. The radio is still playing softly. Traffic is moving around you. Nothing dramatic has happened. At least, not yet. You signal, pull over, and stop. A few moments later, the officer approaches your driver's side window. The conversation begins normally. "Good evening. Do you know why I stopped you?" You answer politely. The officer takes your license and registration, glances into the vehicle, and then suddenly asks a question that changes the entire atmosphere. "Are there any weapons in the vehicle?" The temperature inside the car seems to drop 10 degrees. Maybe you're carrying legally under a concealed carry permit. Maybe you're in a constitutional carry state. Maybe there's a handgun locked in the center console. Maybe your passenger is armed. Maybe you're not carrying at all, but the officer noticed a holster clip, a gun-related sticker, or something that made him curious. Either way, the tension instantly rises. Have you ever been stopped by police while carrying a firearm, been asked about weapons during a traffic stop, or had an officer question you about a gun you legally possessed? Tell me about your experience in the comments, because these encounters can unfold very differently depending on the state, the officer, and even the way a simple question is answered. And stick around, because later I'm going to explain one of the biggest mistakes lawful gun owners make during these interactions, a mistake that often leads people to surrender rights they never realized they had. A lot of gun owners imagine police encounters in extremes. They either assume every officer is looking for an excuse to take their firearm, or they assume that carrying legally means every interaction will be simple and straightforward. Reality is usually somewhere in the middle. Most officers are approaching these situations with one primary concern: uncertainty. Think about the situation from their perspective for a moment. They've walked up to an unknown vehicle. They don't know who they're dealing with. They don't know whether the driver is cooperative, angry, intoxicated, wanted for another crime, carrying a weapon legally, carrying one illegally, or hiding something entirely unrelated to firearms. Every traffic stop begins with incomplete information. That uncertainty affects everything. It affects where officers stand. It affects how they watch your hands. It affects how they interpret sudden movements. It affects how they react when firearms enter the conversation. Many lawful gun owners don't fully appreciate how much attention officers pay to behavior rather than words. A person can verbally say all the right things while simultaneously making every movement wrong. Imagine an officer asks whether you're carrying. The driver immediately reaches toward his waistband. The officer doesn't yet know what that movement means. He doesn't know whether the driver intends to show the firearm, retrieve identification, adjust clothing, or something else entirely. That split second matters. One reason firearm encounters become tense so quickly is because both parties are often worried about different things. The citizen is worried about protecting rights. The officer is worried about immediate safety. Those concerns aren't necessarily incompatible, but they can create friction if either side misreads what's happening. One of the most misunderstood questions officers ask is simply, "Do you have any weapons in the vehicle?" Many gun owners instantly start mentally debating whether they must answer. The answer depends heavily on state law and circumstances. Some states impose a duty to inform when carrying under certain conditions. Others do not. Some states require notification only when specifically asked. Others place no affirmative disclosure requirement at all. This is where people often get themselves into trouble by relying on something they heard online 5 years ago. Firearm laws change. Court decisions change. State statutes differ dramatically. What is perfectly lawful behavior in one jurisdiction can create problems in another. That's why one of the most dangerous assumptions a gun owner can make is believing every police encounter follows a universal rulebook. It doesn't. A constitutional carry state may operate very differently from a state with extensive permit requirements. Vehicle carry laws may differ from general carry laws. Notification requirements may differ from both. Interstate travelers often discover this reality the hard way. Someone who legally carries every day in one state may cross a border and unknowingly enter an entirely different legal environment. The firearm hasn't changed. The person's intentions haven't changed. The legal framework has. And that can matter enormously during a police encounter. Now let's talk about the phrase that inspired this discussion. The idea that if police try to check your gun, there are certain words you should automatically say. The internet is full of videos claiming there is one magical sentence that solves everything. Real life rarely works that way. There is no universal script. There is no secret phrase that instantly protects every right while ending every confrontation. What matters is understanding the legal concepts behind the interaction. For example, there is a major difference between answering questions, complying with lawful orders, and consenting to a search. Many people accidentally blur those distinctions. Imagine an officer asks, "Mind if I take a look in the vehicle?" The question sounds casual. The tone may sound friendly. The wording may sound almost conversational. But legally, that moment can be extremely important. A surprising number of people hear the request and immediately agree without thinking. Maybe they want to appear cooperative. Maybe they assume refusal looks suspicious. Maybe they're nervous. Maybe they simply don't understand the significance. The issue isn't whether someone has something to hide. The issue is understanding what consent means. Once consent enters the picture, the dynamics of the encounter can change significantly. Many experienced defense attorneys have pointed out that people frequently volunteer access to areas officers otherwise might not have searched, and they do it while believing they're helping themselves. The same thing sometimes happens with firearms. An officer asks where the gun is located. The driver becomes anxious. The driver starts pointing, then reaching, then explaining, then opening compartments, then moving items, then creating confusion. Suddenly, everyone is nervous. The officer's concern level increases. The driver's concern level increases. A situation that started calmly becomes unnecessarily complicated. I've seen countless stories from lawful gun owners who unintentionally made things worse simply because they felt pressure to keep talking. Silence makes people uncomfortable. Police encounters make people uncomfortable. Combine those two factors and many citizens begin volunteering information nobody asked for. "It's my gun. I bought it years ago. I carry all the time. There's ammunition over there. I had another firearm in here last week." The permit is somewhere in the glove box, and the talking continues. Meanwhile, the officer is processing every statement, every movement, every inconsistency, every nervous gesture. This doesn't mean talking is always harmful. It means people should understand that stress often causes them to overshare. One particularly risky moment occurs when firearms and glove compartments intersect. Picture a driver who has registration paperwork in the glove box. Picture a firearm sitting in that same compartment. The officer requests registration. The driver immediately reaches for the glove box. The officer notices. The officer becomes alert. The driver suddenly remembers the gun. Now both people are reacting simultaneously. These situations unfold in seconds. That's why calm communication matters. Many experienced carriers develop habits that reduce surprises. They know where documents are stored. They understand where firearms are located. They avoid sudden movements. They think ahead. Preparation often prevents misunderstandings before they occur. Another common scenario involves passengers. People focus so much on the driver's actions that they forget passengers can dramatically affect an encounter. Imagine the officer learns that the passenger is carrying, maybe legally, maybe under a permit, maybe under constitutional carry. Maybe the passenger speaks up unexpectedly. Maybe the driver answers for the passenger. Maybe neither realizes state law treats the situation differently than expected. Suddenly, the stop becomes more complex. Additional questions emerge. Additional uncertainty appears. Again, the issue isn't necessarily wrongdoing. The issue is confusion. Confusion is rarely helpful during police encounters. Something else many gun owners underestimate is how officers evaluate body language. People often assume police are primarily listening to words. Words matter. Behavior matters more than many realize. An officer may observe shaking hands, rapid breathing, repeated glances toward a specific area of the vehicle, unusual hesitation, attempts to conceal movements, contradictory explanations. None of these automatically indicate criminal activity. Plenty of innocent people become nervous during traffic stops, but officers are trained to observe patterns. They're looking for clues. They're assessing risk, and firearms naturally increase the stakes of that assessment. This is where another dangerous myth appears. The myth says that lawful gun owners have nothing to worry about. That's not entirely true. Lawful gun owners absolutely should understand their rights, but they should also understand that misunderstandings happen. Paperwork issues happen. State law misunderstandings happen. Storage violations happen. Permit expiration mistakes happen. Interstate travel mistakes happen. A person can have perfectly innocent intentions and still encounter legal complications. One area that generates significant confusion involves temporary firearm possession by officers during a stop. Some officers choose to leave firearms untouched. Others may temporarily secure them during the encounter. Practices vary widely. Policies vary widely. Courts have examined these situations repeatedly over the years. The important point is that people should understand these encounters can unfold differently depending on circumstances, officer perceptions, department policies, and local legal standards. What often creates problems is not the firearm itself. It's the reaction. A lawful carrier who becomes argumentative, reaches unexpectedly, interrupts repeatedly, or escalates emotionally can transform a routine encounter into a much more stressful event. At the same time, many people swing too far in the opposite direction. They become so eager to demonstrate compliance that they stop thinking critically about their own rights. This is the hidden mistake I mentioned earlier. People assume rights disappear the moment blue lights appear. They don't. The existence of a police encounter does not automatically eliminate constitutional protections. At the same time, rights and responsibilities often coexist. That balance is where many misunderstandings occur. People want simple answers. They want a script. They want one sentence that resolves everything. Real encounters are rarely that neat. Sometimes officers ask questions because they genuinely need information. Sometimes they are investigating possible violations. Sometimes they are trying to determine whether additional safety measures are necessary. The context matters. The legal basis matters. The specific facts matter. And that brings us back to the phrase many attorneys emphasize when discussing police interactions. Rather than searching for a magical line, focus on clear, calm communication and understanding the difference between cooperation and voluntary consent. Many legal commentators suggest that if a person wishes to decline consent to a search, the most important thing is not clever wording, but clarity. A respectful statement that consent is not being given communicates far more effectively than arguing, debating, lecturing, or becoming confrontational. Notice what that does. It removes ambiguity. Ambiguity is often where problems begin. The same principle applies to firearm-related conversations. Confusion creates risk. Clarity reduces risk. Consider the driver who tries to sound sophisticated. He starts quoting legal terminology. He starts reciting constitutional theories. He starts debating case law on the side of the highway. What happens? The stop gets longer. the tension increases. Nobody benefits. Contrast that with a driver who remains calm, communicates clearly, avoids sudden movements, understands applicable state requirements, and does not create unnecessary confusion. Which encounter is more likely to remain controlled? The answer is obvious. Another issue that deserves attention is self-defense language. Many gun owners spend years discussing self-defense scenarios. They train, they carry, they think about worst-case situations, but some unintentionally develop the habit of speaking casually about force. That can become problematic. Statements made during stressful encounters can be misunderstood. Jokes can be misunderstood. Exaggerations can be misunderstood. Offhand comments can be misunderstood. The way people talk about firearms matters, especially during interactions with law enforcement. One final scenario is worth considering. Imagine a completely lawful carrier, no criminal record, valid permit where required,